In this episode, we talk about Hyderabad's urban forest land being set up for auction. We also talk about Kashmir's bridge opening after 6 years. But first, we talk about X challenging the Indian government. Hi, I'm Ichha Sharma and you're listening to Three Things, the Indian Express news show. Billionaire Elon Musk's X platform, formerly known as Twitter, has approached the Karnataka High Court challenging the Indian government's interpretation and application of the Information Technology Act 2000. X argues that the government is bypassing safeguards provided in the IT Act that are specifically meant for the purpose of content moderation.
To understand the legal battle between X and the central government, you have to first understand how the specific provisions of the IT Act that are relevant to this conflict. Those are two different sections. One is Section 69A of the Information Technology Act, and the other one is Section 79 of the Information Technology Act.
This is the Indian Express's Ajoy Sinha Karpuram, who reported on the case for the newspaper.
69 essentially is the content blocking order section of the IT Act, essentially. It allows the government to issue orders to block certain kinds of content after meeting certain conditions. I'll expand on what those conditions are later. Whereas Section 79 is actually a little different. Section 79 is the provision that exempts intermediaries being platforms like X, Facebook, exempts intermediaries from being legally liable for content that is published on their website or on their platform. The reason these two provisions have come into conflict, even though they deal with two different aspects of the content moderation regime, while Section 69A is the direct sort of provision that is meant for content blocking, Section 79 in its third subsection has a sort of exception for intermediaries. While intermediaries are usually exempt from information published by third parties, Section 79 makes intermediaries liable for information published if they have been informed. If the central government comes to this intermediary, to X or Facebook, and says, hey, this X, Y, and Z post needs to be taken down for so-and-so reason, and the intermediary doesn't take it down, then they can be held liable again. If they possess the knowledge that a post is there on the website and they don't take it down after possessing that knowledge.
And Ajoy, speaking of these provisions, can you explain how Section 69A differs from Section 79 in the IT Act in terms of the procedural safeguards?
So now the difference between these two sections is that Section 69A has some protections. It has a very strict process that even the court has come in and clarified to some extent as well. Basically, the section requires the government to deem it quote-unquote necessary to block the content, and the government must also record its reasons as to why this blocking is necessary in writing. Basically, to give X, Facebook, whoever, grounds and information to approach the court if they disagree with the content blocking order. None of these safeguards, and now these safeguards the court has also expanded on. The court has said in the seminal Shreya Singhal case from 2015, the main takeaway from that case was the court struck down Section 66A, which is its own story. But they also expanded on both Section 69A and Section 79 in that judgment. And for content blocking under 69A, the court said that the only reason that content can be blocked, that content can be necessarily blocked, is if it's a reasonable restriction under the Constitution.
And what does that actually mean? Like, on what grounds can the government block content on social media?
So the court held that any content blocking has to take place for reasons detailed in Article 19(2) of the Constitution. This talks about how certain fundamental rights can be reasonably restricted, and this can be on the grounds of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency, morality. Those are the big ones. So if you have to block content, if the government wants to block content, it has to do it on the basis of these grounds. It has to say that this content must be blocked because it threatens the sovereignty and integrity of India, or the security of the state, or public order, or decency, or morality. Basically, the government needs to explain why it's blocking this content so that if there's a disagreement with the blocking order, people can go to court.
Right. And so X is arguing that the government is misusing Section 79 to bypass Section 69A. Could you break this down for us? Like, what is the platform claiming when it says that?
So now what has happened, and the reason why X is in before the court right now, is because under Section 79, the government has sort of used this exception that I previously talked about as a backdoor. So it is now issuing these orders without necessarily according to X at least, the government is now issuing these orders without following the Section 69A process. This started in October 2023 when the Ministry of Electronic and Information Technology directed all central ministries, state governments, police that instead of using 69A process, they can issue information blocking orders under Section 79, or very specifically Section 79(3)(b), which contains that provision on when intermediaries can be held liable. So the government is using this other provision, Section 79(3)(b), to issue these orders now. And this provision doesn't contain those safeguards. This provision doesn't contain the safeguards on having reasons recorded in writing or the content being necessary to block. So after the Ministry of Electronics and Information Technology issued that order saying, hey, you can use this Section 79 now instead, several ministries like the Ministry of Defense, the Ministry of Railways, the Government of West Bengal, just to name a few, have issued notifications in their own jurisdiction to the people who work for them, saying that we no longer have to follow the 69A process. We can now issue these orders under Section 79. And the Ministry of Home Affairs has actually made this even more straightforward because they've created a portal, which X is calling a censorship portal and the MHA calls the Sahyog portal, where each of these ministries and the police can upload content takedown orders onto this portal directly. And the intermediaries will have to make sure that they comply with those orders. So now there is a central point where all of these orders can be uploaded and intermediaries can take a look at these orders. Except these orders aren't being uploaded through the 69A process. They're being uploaded under a section that's actually initially intended to protect intermediaries from content posted by third parties. So there's a little bit of an irony also over there. So that is essentially the main reason why X is before the court right now, because it's telling the court that there is a prescribed process under the IT Act for these kinds of orders that the government is willfully not using because there is a workaround that is easier and doesn't have the same checks and balances. That is what X's argument is.
Right. And Ajoy, as you mentioned before, that now there's a portal, the Sahyog portal, where, several ministries can upload their blocking orders against platforms. But is there any legal clarity on whether this holds the same weight as a court order, for example?
So in Shreya Singhal versus Union of India, the court actually expanded on this a little bit. It's pretty much the same weight. These are the only two ways in which content can be legally blocked, either through a court order or through a government notification, except the court also frames this in that Shreya Singhal case as something that happens under Section 69A. But now, as we're seeing, it's Section 79 that's coming up. So right now, there is a need for legal clarity.
Right. And you also mentioned X's AI chatbot Grok 3 being under scrutiny in your reportage. So how does this tie into the debate?
It doesn't directly tie into this debate, although it's an interesting dimension to the whole issue, because does Grok 3 count as a third party publishing on a website? Because its information is all based on, or rather the AI is trained on responses from active users, but it itself is not a person. So how does this content sort of play into the IT Act? Because as we've been seeing, Grok 3 is, for lack of a better word, acting up right now. And its responses have been simultaneously entertaining, but also a bit concerning. There's a lot of slang being used, different languages, and no one's entirely sure how this has happened yet. So the government is in contact with X to see if there's anything to be concerned about over here. The reason I mentioned it is because we were speaking about Section 79, which at its core is a safe harbor provision, a provision that protects intermediaries from information that's published on their website. But what about information that's coming from X's own AI tool? Do they have safe harbor from that? So that is a real question that needs to be considered. It may or may not be considered in this case. It likely won't, but it's another question that we should seek answers for.
And also, Ajoy, what precedent might this case set, for other social media platforms in India?
It could absolutely be a pivotal case for other social media platforms because it's a case that will likely define how the government can do content moderation in the future and the options that the government has in the future. And every social media platform is likely paying very close attention to this case because it will define how their operations are run in the future and how much protection they are going to be given from third-party information being published on their platform and what they can do about it.
And lastly, Ajoy, what should we, as users of these platforms, be watching for in this legal case?
Users are going to have to look out for a lot of the same things that companies are now looking out for, which is what are the government's powers when it comes to content moderation and the effects it could have on the kinds of things that they could post from here on out, depending on how this case goes. Because depending on how this case goes, there might be a different standard for taking down content, talking about content that's being created by these users, and what the half-life of that content is and what action can be taken on that content. Although that's arguably a different issue and there are different laws for that as regarding what action can be taken against users. But just for this issue, users are going to have to see how this shapes social media platforms going forward and how this shapes their interaction with these platforms going forward.
And next, we talk about people in Telangana protesting to save an important urban forest. A proposal to auction off 400 acres of land in the Kancha Gachibowli village near Hyderabad has sparked strong opposition from nature conservation groups and local residents. The land currently held by the Telangana Industrial Infrastructure Corporation is being considered for auction to develop IT infrastructure and improve urban connectivity. In response, conservationists and locals are urging the government to protect the area by declaring it a national park, much like Hyderabad's Kasubrahmananda Reddy National Park. In this segment, the Indian Express's Rahul V. Pisharody takes us through the ongoing debate and what this case means for urban land use and conservation efforts. Rahul, this forest we understand lies in the Kancha Gachibowli village. Could you start by telling us where this lies and why is this land so important?
So, Kancha Gachibowli is an area on the western part of Greater Hyderabad and is located in Rangareddy district. Last month, the state government announced a proposed auction of 400 acres of land here for revenue generation. The auction of land is supposed to earn at least rupees 10,000 crores. Since then, this land has become a focal point of environmental concern. That is because Kancha Gachibowli, we can say, is one of Hyderabad's remaining urban forests, acting as a vital green lung space for the city. The area is rich in biodiversity, hosting a wide variety of flora and fauna, including numerous bird species, mammal, and reptiles. It contains beautiful rock formations such as Mushroom Rock and acts as an extension of adjoining University of Hyderabad's forest ecosystem. Since then, there have been protests, especially by University of Hyderabad Students' Union. Environmental activists stress on the need to preserve Kancha Gachibowli biodiversity and its role in maintaining the city's ecological balance. The 400-acre land is also located in the midst of financial district here, which has experienced rapid economic growth, particularly in the IT sector. This has led to increased pressure for development with proposals for infrastructure projects and real estate development. Thus, a debate between development and the need to preserve the natural environment.
Right, and you talked about the region being a natural carbon sink. So, can you explain why this characteristic matters?
So, environmentalists argue that forests such as Kancha Gachibowli absorb atmospheric carbon dioxide through photosynthesis. This carbon is stored by trees in their biomass and in the soil. Carbon dioxide is a major greenhouse gas that contributes to global warming, and through carbon sequestration, it helps to reduce the concentration of carbon dioxide in the atmosphere. So preserving existing carbon sinks is crucial for achieving climate goals and limiting the impacts of climate change. Urban forests also help to regulate local climates by providing shade, reducing temperatures, and increasing humidity.
And Rahul, as you mentioned that the Telangana government is planning to auction this land, and this has led to concerns about what this would do to the local ecology. So, has the government given any official reason for taking this action?
So beside the announcement, the fact is that state government has repeatedly talked about the state's debt burden and the need to generate revenue from newer sources. This auction is certainly one such option available with the state government. Moreover, the government plans to use this land for developing IT infrastructure, we are told, and improve connectivity in the area and also create sustainable urban spaces. Gachibowli IT corridor is one of the most expensive localities in Hyderabad city, and land values are very, very high here. It is quite natural that 400-acre land parcel under the government's ownership will be used for development.
And have they spoken anything about how they plan to ensure the preservation of this region's ecology?
So very less of government's plan is out in the public domain. The Telangana Industrial Infrastructure Corporation says it has prepared a layout duly preserving rock formations, including the mushroom rock, in this land area as green spaces within the layout. As part of the master plan, a detailed environment management plan is also being prepared to ensure sustainable development of the region.
Also, during your research, you spoke with a few environmentalists and also residents who have been protesting against this auction. So, could you tell us what did they have to say and what are their main concerns?
So, there are, in fact, two groups which are protesting to protect this land. One, who are nearby residents who have grown up seeing this green patch of land and enjoyed the biodiversity and want to protect it. They are called Save City Forest. Second is the students of University of Hyderabad. The students claim that this land was originally part of University of Hyderabad campus when it was established in 1974. Gradually, a lot of land was taken back by the state government for development of infrastructure, including a bus depot. This particular piece of land has been in litigation for over 2 decades, and a High Court division bench last year gave its judgment, declaring state government as the sole owner of this land parcel. The university was not party to this case between government and a private sports management company. So even today, the university is clear that it is not owner of the land. However, students feel that the land is crucial considering the expanding nature of university and future research and academic purposes.
And Rahul, legally, is there any precedent for protecting such lands?
So activists are citing the 1996 T.N. Godavarman Tirumalpad versus Union of India case, where the Supreme Court held that any land with forest cover qualifies as forest land even if the land is not notified as a forest, and that the term forest is to be understood in the dictionary sense of the word. So the Save City Forest group also emphasizes that any move to clear forest cover with Schedule 1 species without any environmental impact assessment or environmental clearance is a grave offense under the wildlife and environmental laws. They also want the government to hold the public trust doctrine, which is a legal principle that establishes that certain natural and cultural resources are preserved for public use, and the government holds these resources in trust for benefit of the public for the future.
Right. And also, Rahul, people have been comparing this forest with the KBR National Park. So what would you say makes Kancha Gachibowli similar to KBR, in terms of ecology and also land status?
So KBR or Kasu Brahmananda Reddy National Park in Hyderabad is located between upmarket Jubilee Hills and Banjara Hills and is a major urban lung space for the city. It is also frequented by the rich and influential, from film stars to politicians, for a stroll in the morning and evening. It is spread across 390 acres and rich in biodiversity, just like 400-acre Kancha Gachibowli land. Now, both these forests have wide variety of plants and animals, including Schedule 1 species. So activists are arguing that KBR, which was originally part of Nizam's estate, was taken over by the government in the 1990s after recognizing its ecological importance and to create a vital lung space for the city. The land was then handed over to Forest Department and government notified it as a national park. The activists want Kancha Gachibowli land also to be notified as a national park and protected for the future.
In the end, we give you a quick update about a bridge reopening after 6 years. In Jammu and Kashmir, the Kaman bridge in Uri sector was opened for the first time in 6 years on Saturday to facilitate the return of the bodies of 2 individuals who had drowned in the Jhelum River. According to the Indian Express's Bashrat Masood, the deceased, a 22-year-old man and a 19-year-old woman, were reported missing after allegedly entering the river 2 weeks ago. Masood reports that the body of the man was initially spotted on the Indian side, but was swept into Pakistan-occupied Kashmir due to strong currents. The woman's body was recovered earlier in the same region. Following official coordination, the Indian Army and its counterparts in POK facilitated the repatriation of both bodies across the line of control via the Kaman post. For those who may not already know, the Kaman bridge was originally intended for cross-border trade and travel. It was opened for the first time in 2005 and has been non-operational following the suicide attack that killed 40 CRPF troopers in Pulwama attack in 2019. Its temporary reopening has renewed attention on cross-border humanitarian engagement in the region. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and produced by Shashank Bhargava and me, Ichha Sharma. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.